Stahowski,
Yes.
you're supposed to be here in person. Why are you not here?
My letter tells me it's Zoom on 6/20.
Ladies and gentlemen, buckle up because today we're diving into a wild courtroom saga featuring none other than Daniel Howski, better known as Richard, or as the judge soon discovers, a full-blown problem child of the legal system. This isn't your run-of-the-mill probation hearing. Oh no, this is a collision course between one man's excuses, a judge's patience, and the inevitable consequences of playing games with the court. In this video, you're going to witness everything. Contradictions, emotional outbursts, a defendant convinced the system is out to get him, and a judge who somehow keeps his cool while holding the line. Pay attention closely, because what starts with a simple failure to appear quickly snowballs into a standoff about respect, responsibility, and the cold reality of jail time. And trust me, you'll want to stick around until the end, because this case escalates faster than you can say contempt of court.
That's what my letter tells me.
I'm looking at the notice that was sent out.
All right, I have it right here in front of me.
Mr. Stahowski,
Yes.
your original letter that was sent out on March 23rd said that it was to be via Zoom. Another letter was sent out on May 13th because instead of a review, it was going to be a violation. And that violation was changed to be a hearing in court. And Mr. Marana tried to reach out to you regarding this and was unsuccessful. So did you not have the right contact information?
So I did not have any good contact for him. I have emailed him and he has scheduled to appear for appointments on May 23rd and June the 7th as well. So I've had no contact with Mr. Howski for.
When's the last time you had contact with him?
Last time we had contact was May the 9th.
So, Mr. Stahowski, how did you think probation was supposed to go? Did you think that you just checked in when you felt like it?
No, not at all. I understand my civic responsibility. That's why I'm with you.
Here's where we hit the first major red flag. The defendant claims he thought his appearance was scheduled later, based on a letter. But the court has receipts, literally. The judge pulls out both notices, one for a Zoom session, later updated to an in-person violation hearing. Now, in legal terms, this is where credibility starts slipping. Courts keep records for this exact reason, and the paper trail proves the defendant was informed. Yet instead of taking responsibility, he leans on the "I didn't know" defense. Let me ask you, do you think this is genuine confusion or a classic stall tactic? Drop your thoughts in the comments below.
Your Honor?
Yes.
I'm in the process of moving, and I've changed locations. And since I moved locations, my email has able to get a hold of my probation officer through my email. And I'm dealing with that right now.
Well, is your phone number the same?
No, I got a different.
This moment is almost surreal. The defendant claims his email was locked after moving to a new address. Think about that for a second. Have you ever heard of Gmail asking for your new zip code before letting you log in? Exactly. The judge doesn't even need to call it out because the absurdity speaks for itself. What we're really hearing here is excuse stacking, when one flimsy explanation isn't enough, so another one gets piled on top. First it was the wrong date, now it's the magically blocked email. Viewers, be honest. If this was your probation officer, would you buy this story for even 1 second?
When you're on probation, when you change address and phone number, don't you think it would be a good idea to make sure your probation officer knows that?
Well, I think it's a good idea, but you got to understand I've been dealing with my father's death that I caused, and I've been dealing with cleaning out the house, and I've been trying to find an apartment. Yes, I understand that, and I do understand my civic responsibility. I do, this is the first contact that I've gotten at this location, and I'm happy to give my phone number.
So I will adjourn this 1 week. So it will be set again a week from today. At the same
Why do you
time.
want to see me in person? I don't know if I can go down there. I'm not sure if I can do that. I don't have a driver's license. I cannot drive. I can't be going anyplace. You know, my license is restricted. So I'm not really sure whether or not, and I'm not sure the reason you want me down there. For what reason? To put me in handcuffs and put me in another 44.
This will be real simple. I'm just gonna, I want to make sure you can hear me okay, and I'm a little concerned at your tone.
Well, I'm a little concerned about what you're stating. I'm a little concerned. You want me down there for what? For what reason?
Okay, so I will note today that Mr. Jowski was aware that he was supposed to be here today. Mr. Jowski has indicated that, oh, hang on a second. Mr. Jowski, can you hear me? Mr. Jowski, can you hear me?
Yes, I can, officer, or honor.
All right, this is real simple. I'm indicating to you right now that it is the order of this court that you present yourself to the court a week from today. Are you telling me?
I'm not going, Your Honor, I'm not going to court. I cannot get there, all right? Period.
This is where the case takes a sharp emotional turn. The defendant brings up his father's death, even acknowledging he caused it. Now, grief is real, and courts often account for personal hardship. But here's the problem. Using tragedy as a shield for probation violations rarely flies. The judge shows empathy, recognizing the difficulty of losing a parent. Yet the underlying issue remains. Probation requires communication and compliance, regardless of circumstances. Notice how the judge balances compassion with accountability here. This is courtroom dynamics at their core, the human side of justice clashing with the system's need for order.
The probation officer knows my, and he can adhere to that. I cannot go to court. Last time I went to court, they put me in handcuffs and put me in jail for 44 days. I'm not going to Macomb County, but I know why you want me to go down there to put me in handcuffs. What the hell did Your Honor, what did I do? What did I do?
Mr. Chahowski, I'm happy to explain it to you. You have failed to appear for probation appointments.
No, I did not. No, I did not. I told you why I didn't.
Boy, that escalated quickly. I mean, that really got out of hand fast.
Listen to me.
All right, Mr. Chahowski, I'm not gonna tolerate you speaking to the court in that tone. You failed to appear today. You've indicated, no, Mr. Chahowski, I've hit you on mute. I have nothing more than I need to hear from you. I've indicated to you that you have 1 week from today to appear at the court. If you're not here a week from today, then you're absolutely right. You will find yourself in a jail cell a week from today. If you show up a week from today and perhaps explain to me what's going on with you in a manner that's respectful, he's not listening. No.
Now things really heat up. The judge makes it clear. Show up in person next week or face consequences. And what's the defendant's response? A flat-out refusal. He insists he cannot and will not attend. This is where the power dynamic flips. The judge isn't threatening jail lightly. He's giving the defendant one last chance to comply. But the refusal to even consider showing up shows us what's really happening. Fear, defiance, and maybe a dash of paranoia. I've got to ask you, if you were in this situation, would you double down on defiance or swallow your pride and show up?
I'm going to adjourn this violation for 1 week. I'm going to adjourn this violation and it's going to be in person. Now, during that week, I am inviting you to reach out to your probation officer because nothing is etched in stone. Your last experience where you went in person to court, you did 30 days, okay? Now, you are not in compliance with probation, but that doesn't mean that I automatically go to the consequence of a jail sentence. Because I know, Mr. Chahowski, that with you there are also You know, there are many different challenges, including some mental health challenges that you try to work through. And I know that your rage at the court right now and inappropriate behavior today is a byproduct of fear and a byproduct I know there to be a significant mental health challenge. So I am willing to wait and pause and give you a week to respectfully reach out to probation, understand why you're in violation, try to see if you can correct those violations and come up with a plan outside of the jail setting. I am at least willing, even now, to consider those opportunities. I have not made a snap judgment about you, Mr. Chahowski. I have not come to the conclusion that you are unredeemable or that you need to do 93 days in jail. I simply ask that you not make a snap judgment about me or my probation department. Everybody here is required, wait, I will unmute you in a second. Everybody here is required to meet certain standards. You are here for criminal behavior that needs to be addressed. I know when your mouth is open, sir, that you're not listening to me. I know when your mouth is open, I will unmute you and you can make some comments in a second. All right? But I know when your mouth is open, you're not hearing me. You made an assumption. You've made an assumption that I'm trying to figure out a way to put you in jail. All right? I'm simply trying to get you to come here as anybody else who has a violation. Everybody else who has a violation is here today in person. Everybody else. I don't have a special set of rules for Daniel Chahowski.
Here comes the explosion. The defendant goes from defensive to aggressive, raising his voice and challenging the judge directly. What did I do? At this point, courtroom etiquette is out the window. Judges can only tolerate so much disrespect before contempt charges come into play. But what's remarkable here is how calm the judge stays, even while being talked over. He cuts through the noise with one simple fact. The defendant failed probation check-ins. No distractions, no excuses, just the record. It's a masterclass in judicial patience and a reminder that when emotions run hot, facts remain cold.
That although you are not present in court, in court as far as in person, you are still in a court setting. You are still in a court setting. So if you are disrespectful, rude, if you are if I unmute this, sir, and you use language that's inappropriate, I can find you in contempt of court and sentence you to jail. Yes, I can find you in contempt of court.